Hello and welcome to the Tennessee Informer. Thanks for joining us tonight. Last week, in the case U.S. versus Kermit, the Supreme Court heard oral arguments concerning Tennessee's SB 1 passed in 2023, which banned certain procedures and puberty-blocking drugs where transgender minors were concerned, so-called transgender minors. These laws prohibited healthcare providers from administering puberty blockers, hormone therapy, and sex transition surgeries to minors for the purpose of altering their appearance or validating their gender identity when inconsistent with their biological sex. The law included exceptions for certain medical conditions and provided mechanisms for enforcement, including professional discipline for healthcare providers and extended statutes of limitations for lawsuits. In response, groups of transgender minors, their parents, and healthcare providers challenged these laws in federal court. The plaintiffs argued that the laws violated their constitutional rights to due process and equal protection. They sought preliminary injunctions to prevent the laws from taking effect. In both cases, district courts initially granted injunctions, finding that the laws likely infringed on parents' fundamental right to direct their children's medical care and discriminated based on sex. Well, I don't see how gender mutilation would qualify as medical care, but okay. The U.S. Court of Appeals for the Sixth Circuit stayed these injunctions, allowing the law to go into effect pending further legal proceedings. The question that the supporters or that the opponents of SB 1 asked the court, the ones who wanted our law, SB 1 overturned, was, does a Tennessee law restricting certain medical treatments for transgender minors violate the Equal Protection Clause of the 14th Amendment? As far as SB 1 goes, this is some rare, good, and needed legislation passed by our usually pathetic Republican supermajority. Good to see our AG fighting for this, and good to see the Tennessee Solicitor General, Matthew Rice, make a straightforward case. Elected lawmakers, not federal judges, should evaluate emerging medical evidence and set appropriate policies, not unelected federal judges. More on that issue in a minute. But before our Republican supermajority passed this good legislation, SB 1, let's not forget about the very bad, I would call, pro-transition legislation that they passed overwhelmingly in 2021 on this very topic. Hell's Fail, as it's known in the Senate. It was Senate Bill 126, House Bill 1027, supported in the House by Kumar, if I remember correctly. Was passed in April of 2021. Now, if you go, the bill was initially a caption bill, and a caption bill just gives you very, very little information on it. It just lists the relevant Tennessee code, and you can't look at a caption bill and know what is really going to come out of it. Sometimes something good comes out, sometimes something bad comes out, but they do use caption bills. Anyway, the amendment that made the bill was SA 202, Senate Amendment 202. And this is the language of the bill that was passed in 2021 by the same virtually the same Republican supermajority, minus a person or two here who may have gotten elected since that time. This is the language of the bad bill passed by our legislature in 2021. And let's start here with the enacting clause. Section 1, Tennessee Code Annotated, Title 63, Chapter 1, is amended by adding the following. As a new section, as used in this section, healthcare prescriber means an individual licensed under this title and authorized to prescribe medications. 2, minor means a person who is less than 18 years old of age. And 3, prepubertal minor means a minor in Tanner Stage 1 development. Basically, that's 8 years older. 8 years and younger. Okay, that's That's a minor in Tanner Stage Development 1. Standard medical practice does not involve prescribing hormone treatment for gender dysphoric or gender incongruent pre-pubertal minors, except as provided in subsection C of this law. And it says a healthcare prescriber shall not prescribe a course of treatment that involves hormone treatment for gender dysphoric or gender incongruent pre-pubertal minors. A healthcare prescriber may prescribe a course of treatment that involves hormone treatments for prepubertal minors for diagnosis of growth deficiencies or other diagnosis unrelated to gender dysphoria or gender incongruency. Section 2, standard. This section takes effect upon becoming a law. The public welfare required it. I don't think the public welfare required that particular law. SB 1, absolutely. This one, no. Now, we're going to see a video here in a little bit about Farrell Hale talking about this bill when he wanted it passed in 2021. And it puts, during the campaign, this past campaign season, he had a challenger, Chris Spencer from Sumner County, was challenging him. And of course, the Spencer campaign knew about this, and they were letting the voters know about this. And so let me scroll down here just a little bit. This stuff came from the Spencer campaign that I saw out there somewhere. And they've been sounding the alarm about Senator Hale, his legislative record, especially his support of SB 126, which allowed the continued application of hormone blocking agents to minors as young as 9 years old. Now, remember, the Tanner Development Stage 1 is 8 and below, okay? So 8 and below, they weren't giving these to, but that was already the standard medical practice. They weren't doing this for anybody 8 and younger. His bill codified that, okay? Hale and his surrogates have flooded the market with denials that the bill actually was intended to do that. Candidate Spencer, Chris Spencer, following a meeting with his campaign team, said that other media have gone to print and basically blasted him for misunderstanding Hale's bill. The bill that was passed by Hale, supported by everybody in the Senate, unfortunately. I think almost every Republican voted for this bill. Now, I did look at the bill last night, and maybe I overlooked something. I did not see Senator Johnson's name on there, and there were at least 2 other senators' names missing because we have 33 senators, and there were only 30 that voted on it. Usually, if there's somebody who's there and is not voting, they will list them as present, not voting. So there are a few names. There are a few that didn't vote for it. Only name that stood out was Senator Johnson, which kind of surprised me. I'm not taking up for him. I'm just saying this bill was widely supported by the Senate and the House. All right, the Spencer campaign has already dealt with, I'm having some trouble here with the slide, okay, with the matter of Senate Republican support for this hideous legislation. They referred to Senator Janice Bowling's letter describing her belief that she and her colleagues were misled on the legislation, and that Hale, vice chair of the Senate Health and Welfare Committee, also shut her amendment down when she attempted to reverse the intent of his bill. Further conversations with Republican senators yielded obvious confusion and discontent with Hale for misleading them, and professed apologies for supporting the bill. Let's go ahead and play the video so that you can hear what Hale actually says in the video, and then I'll come back to the commentary here. This is
126 on third and final consideration with the purpose of bringing up the amendment that makes the bill. Any hormone treatment of gender dysphoria of children prior to puberty. What we're doing here is the current practice of medicine indicates that hormone treatment for gender dysphoria is not starting until after puberty begins. So this amendment simply ensures that this remains the case. This means anyone currently in Tanner 1 state which has not entered puberty. This just codifies what the medical folks say is already the standard of practice.
Okay, so He mentioned Tanner State's Development 1. He mentioned this is what Vanderbilt was already doing. Okay, so they weren't giving this medicine, these treatments to kids 8 years and younger. So when you read that, and I've already read off the bill to you, and we'll see some more information here in a minute. That means from 9 to 17, it's fair game. That means Hale, and at the time, our state legislature supported, whether they realized it or not, what Vanderbilt was doing in transitioning kids from 9 to 17, still minors. Now remember when I showed you a few minutes ago, I showed you the amendment that made the bill, because it was originally a caption bill. I showed you, and it defined minor, and then it defined a prepubertal minor. It defined that, and it made reference to Tanner State's Development 1. So how could they read that? And it's only a one-page bill. A lot of these bills, 3, 4, 5, 6 pages. This is a one-page bill. I don't know how anybody could have read that bill and not come away with understanding that, okay, this means that they can transition kids from 9 to 17. Well, actually, from 9 to 17. Minors from 9 to 17. Once they're 18, obviously it's their own call. Our state signed off on that. Almost all the same people who passed SB 1, which is a good bill, supported this bill, House and Senate. Now, I'm glad they corrected their error, okay? But the correction came, as we'll see here in a little bit, not because Farrell Hale realized he'd made a mistake, but because once somebody, an out-of-state celebrity, I guess you could say, kind of got involved and shed light on what was going on, then it became a big issue. So let me scroll down here just a little bit. Okay, you saw the video. He's reading before the Senate and declaring in finality, this bill codifies what the medical folks say is already the standard of practice. And Vanderbilt Medical Center proceeded with Hale's permission to harm children until called out by Matt Walsh of the Daily Wire. Okay. Now, those are Hale's words about what the bill did. Nobody else made that up. Those are his words about what he did. Okay, now slide down here just a little bit. Okay, so how Hale could not know what he was saying or doing is beyond, I don't understand how he and everybody in the House and Senate couldn't have read that and wouldn't have read that, and a red flag jumped up. Now, I know there are in the Senate a very few decent people, and we'll talk about that in a minute. And so I don't know if they didn't read the bill. I don't know. I guess they just took Hale's word for it. I don't know what the hell they were thinking, but that was a bad idea. So he's tried to backpedal during the election. Now, he did win re-election. That's really a sad statement, in my opinion. With as pro-illegal alien as he was, and on this bill, I would have thought the people from that district would have sent him packing, but he did win re-election. Let me slide down here just a little bit. So once the word got out, and so the bill was passed in 2021. In 2022 is when Matt Walsh did his expose on Vanderbilt and everything Vanderbilt was doing with minors as far as all these treatments and surgeries. And then it was brought to the legislators' attention that, hey, this bill that you guys passed in 2021 is facilitating this garbage. So right off the bat in 2023, SB 1 was filed in the Senate by Jack Johnson, in the House that was by William Lamberth, okay? And so they did get that one straightened out. And I want to hit a couple of other points here just to make sure, okay. And this is something else that I didn't write. This was from the campaign at the time. Fact, if Hale's bill did not support this, then why was Matt Walsh needed to expose it and require the legislature to reverse itself? Hale himself should have pressed Vanderbilt. Fact, every Republican senator did support it before they didn't. Like I say, I found 3 names missing. The only name that popped off the top of my head was Johnson originally, unless I've just overlooked that. But the vast majority of House members, the GOP members in the House and Senate passed it. And we have a Republican supermajority. Nothing good, nothing bad happens without our Republican supermajority involved. I mean, the Dems are virtually the phone booth club. They have no power. One GOP senator who supported the bill was asked if Hale's fail actually limited what Hale said it did, then why was Vanderbilt abusing children as young as 9? His response was, our caucus failed in reviewing this legislation. This bill actually opened the door to Vanderbilt. That's what one of the members said. When asked what outside forces would have been pushing this legislation, the answer was feral Hale. Fact. Hale's fail was so bad that the Senate made it its #1 priority to demolish it. That would be SB 01, the good bill, which is now being defended in the Supreme Court. Even at that, Hale failed to join his Republican colleagues in their mea culpa legislation the first 2 readings and voted only when the final vote came. Fact. Hale's claim that his bill paved the way for a better bill doesn't hold water. All he had to do was ban all minors, but ban these procedures for all minors. They define minor in the bill. So I don't understand how anybody read that bill and said, well, why are we not just banning these things for all minors? So not only did Hale fail, he blocked Senator Bowling's more restrictive bill that would have done just that. So bottom line is, for whatever reason, Hale pushed this. Way too many people went along with it or didn't pay attention, whatever the case was. Hey, they're all to blame. Don't get me wrong. They're all to blame. You put your name on a bill, you sign off on a bill, you own it, okay? Now, part of the problem is they do way too much legislation up there. House and Senate, they do way too much. The House has a limit of 15 bills that each representative can file. And of course, he has to have a Senate sponsor to go along with that bill. But the Senate's not limited. And the Senate has to have a House sponsor. We end up with, I think it's something like, I've heard numbers like 1,500, 2,000 bills that get filed every year. Now, how many actually make it through the committee process and make it to the floor? I don't know that right off, but I can tell you this. We have way too much legislation. There's no way people can read all that legislation, comprehend. Now, on this bill, though, guys, remember, it was a 1-page bill. And also, this is a lesson for those of you who just, oh, well, I trust so-and-so. Hey, you know what? So-and-so may or may not be trustworthy. Number one, in the Senate, you know there's only a handful that are trustworthy, okay, who are not going to deliberately mislead you on something. But what if some of the better ones maybe just missed something, didn't understand something? They got that bill from somebody else. Most of the legislators don't sit up there and write up their own legislation. Most of the legislation that they get is brought to them by somebody. It's generally not somebody from the general public. It's generally a lobbyist, okay? So even a well-intentioned legislator that signs up for something, writes something up, he or she might overlook something and give it to their buddy for support, and maybe, hey, they always support each other, and you can miss something. So I would think, one thing you do is, number one, you still don't sign off on something without reading it, just because you got it from somebody that you trust, because honest mistakes can be made. Oh, and by the way, if you're in the Senate, there's only 5 or 7 people up there, maybe, that you can trust. Let's see. There's a couple more. Oh, another fact here. Quoting the bill does nothing to prove the power to block anything. The bill didn't, his bill, 126, didn't block anything. It just basically codified what Vanderbilt and other medical institutions were already doing in terms of gender mutilation for these children. Basically, I consider it crimes against nature. And let's slide down here. Okay. This is more campaign stuff, so we're pretty much through with the campaign stuff. But hey, our Senate is pathetic. And here's something to remember. This goes back to the recent elections. But okay, so it's obvious that Hale's fail was a serious fail. You know how hard McNally, Lieutenant Governor McNally, who has all of its own problems with, look, the guy made Tennessee famous on Saturday Night Live in not a good way, with his little online romance with a young gay guy. I mean, McNally's like 78, 79, and here he is basically going back and forth, flirting online with a known homosexual. If you haven't heard about that, it's out there. Our lieutenant governor is a pervert, bottom line, okay? But he was all in for getting Farrell Hill reelected. And let's not forget old drunk Ken Yeager made some news down there in Jekyll Island, Georgia this past weekend, pissing all over himself during a DUI, or before the DUI, after the DUI, whatever. Yeah, he of course contributed to Farrell's campaign as well. That's what they do. They support each other. They spent a lot of money, put a lot of effort to support the reelection of Farrell Hale, even after this. Okay, all these things were in the past. They were known. They were all in. They spent big bucks to keep him in there. Even the state senator here in this district, John Stevens, went to fundraisers or was listed as one of the people involved with fundraisers for Farrell Hale. And of course, McNally supported Stevens as well. Just keep that in mind. So I'm going to slide down here just a little bit. I guess the question is, or one of the questions is, if, SB 1 should have been passed a long time ago. So when we found out what was going on in Vanderbilt, why wasn't an SB 1 type bill passed then? Why weren't all minors restricted from these procedures then? They should have been protected then. And if Matt Walsh hadn't exposed Vanderbilt and exposed our legislature, would we have an SB 1? Or would Farrell's bill still be covering for Vandy's crimes against nature? So I have to wonder, without Walsh, there may not have been any SB 1. Because once Walsh made it public, that's when the legislature got on the ball and passed SB 1. Now, it was all mostly the same people. I don't understand how they couldn't have read a one-page bill and not seen the obvious problems with it. I don't understand why they couldn't have made it then illegal to give any of this stuff and do any of these things to anybody under 18. I am glad they passed SB 1. It's a good bill. It's needed. I'm glad the AG's defending it. I'm glad the Solicitor General is making a good defense. But you have to wonder why an SB 1 bill, SB Type 1 bill, wasn't passed in 2021 instead of the garbage that Farrell Hale and our supermajority legislature, Republican supermajority legislature, jumped on the bandwagon with. We could have had SB 1 a few years ago. Should have had it instead of this garbage from Hale. So now I want to switch gears back to the current Supreme Court case. And now what I'm going to read here initially is not something I wrote. This is actually something from Tennessee Stands. Gary Humble sends out like a weekly or bi-weekly letter, and he wrote a good commentary on the situation there. So what I'm getting ready to read came from Gary Humble and Tennessee Stands. It's not something I wrote up, but I thought it was excellent. I thought it fit the bill, so I thought I would go ahead and use it. Thank you, Gary, by the way. And what I also did on my own is I went and I read the transcript of the court trial. Now, I didn't read the whole thing. I read primarily the interaction between our Solicitor General and the court, the different court justices. And I include here, I guess, in my opinion, the strongest points made by our Solicitor General, and then something that was said towards the end that I want to raise some questions about. All right, and this is what I'm getting ready to start with is from Tennessee Stands. Justice Barrett raised crucial questions about creating new protected classes through court decisions rather than legislation. As Rice explained, this kind of policymaking belongs in state houses and Congress, not courtrooms. If courts can simply declare new protected classes whenever they want, what is left of the democratic decision-making? In a remarkable moment of constitutional clarity, Tennessee Solicitor General Matthew Rice stood before the nation's highest court and delivered a message they needed to hear. The Supreme Court has overstepped its bounds by creating quasi-suspect classifications for discrimination protection, telling the Supreme Court directly that they've exceeded their constitutional authority. Rice boldly stated that the court should not be in the business of creating new protected classes. Let's appreciate the significance of this moment. Here was Tennessee's top appellate lawyer, representing the will of the state legislature and its people, telling the Supreme Court directly that they've exceeded their constitutional authority. In the hallowed chambers where advocates typically tread carefully, Rice boldly stated that courts should not be in the business of creating new protected classes. That's a job for legislators. This matters because for too long, courts have been steadily expanding their role beyond constitutional boundaries. When Justice Barrett questioned the lack of historical discrimination against transgender individuals as protected class, Rice seized the moment. He explained that courts have gotten out of the business of creating new quasi-suspect classes precisely because it's a very unprincipled test. This wasn't just a legal argument. It was a fundamental challenge to the court's assumed authority. And boy, does the court take a lot of assumed authority. The volunteer state lived up to its nickname. Rather than simply arguing within the framework the court has created, Tennessee challenged the framework itself. Rice essentially told the justices, you've been doing something you don't have the constitutional authority to do, and it's time to stop. And that was a paraphrase from Gary. This is exactly the kind of principled federalism we need to see more of from state governments. Too often, states accept the steady erosion of their authority without pushing back. But Tennessee showed that states can and should challenge federal overreach, even when that overreach comes from the Supreme Court itself. I would say especially when it comes from the Supreme Court itself. Tennessee's bold stance reminds us that our federal system works best when states actively defend their legitimate authority. By challenging the court's practice of creating protected classes through judicial decisions rather than leaving such policy choices to legislature, Rice did more than just argue the case. He defended the constitutional separation of powers itself. Yes, there's a constitutional separation of powers between the states and the federal government. All the power does not belong to the federal government. Let's be honest about what the Biden administration is trying to do here. They want to force every state to accept controversial medical procedures for minors regardless of what parents, doctors, or state legislators think is best for their communities. They're trying to use the Equal Protection Clause to impose a one-size-fits-all policy nationwide. Tennessee's law takes a reasonable approach. It doesn't ban treatment options. It simply says wait until adulthood before making irreversible changes to healthy bodies. As a society, we have already restricted many decisions until adulthood: voting, drinking, smoking, and getting tattoos. Why? Because we understand that children need to mature before making certain choices. Okay, now that concludes everything I just read. Pretty long bit there. That was from Tennessee Stands. Okay, I didn't write that, but I thought it really hit the mark, so I used it. Hats off to Gary Humble, hats off to Tennessee Stands, and hats off to Mr. Rice. He is spot on. Although he would only go so far as seen in a later statement. Like I say, I read primarily his interactions with the justices. I really didn't care about the wacko libtards pushing their transgender garbage, okay? I mean, I may go back and read it just so I know everything about it, but I really wanted to focus on what Mr. Rice was saying. Now, I guess because of the things that Mr. Rice had said earlier, Chief Justice Roberts was starting to wonder a little bit. And so he asked this question to Mr. Rice. Counsel, I want to be clear about this. I assume you agree with me that no matter how difficult the science may be and no matter how evolving it may be, at the end of the day, legislation on this subject is subject to judicial review. Mr. Rice responded, yes, Your Honor. Chief Justice Roberts said, is that correct? And I also want to be clear that the issue about the difficulty of regulating the science and attempting to figure out where to sort of stop and place the scale in the evolution is a matter that goes to the level of judicial review. Is that right? The level of scrutiny that's applied. And Mr. Rice said, yes, Your Honor. So now, I really, like I said, appreciate what Mr. Rice said initially up front. And I'm not surprised, per se, at his response with the Chief Justice. But I think the Chief Justice was starting to feel challenged by all these obvious problems being pointed out on the authority, or lack thereof authority, in my opinion, of the court. And so I guess Justice Roberts, the guy who gave us Obamacare, who redefined it as a tax, just wanted to make sure that Mr. Rice understood who was running the show here. And here's the problem. Here's the real problem we have in this country, and we've had it for a long time. Most people believe the garbage just spewed by our Chief Justice. They believe that's our system. Now, have we as a country generally deferred to the court? Yes. Is that what the Constitution requires? No. That mentality makes most of what's in here moot. One thing I want to say real quick on this. They mentioned the Equal Protection Clause and due process. That's from the 14th Amendment, okay? Now, we're going to have Jeff Cobble here next week, and we're going to talk exclusively about the 14th Amendment and the perverting of it. So I don't want to get too deep into that. But the Equal Protection Clause and due process, that's all from Section 1 of the 14th Amendment. Well, if you know anything about history, and if you read this, it is pretty obvious, this was about the freed slaves, okay? Now, they have taken Section 1, and yes, it does ensure that people's rights are not denied. I am not denying that. But it doesn't give the court the right to create whole doctrine. If you read through the, of course, this oral argument and any others, you'll see references to different levels of scrutiny. Let's see, what was it? Rational basis, intermediate, and then there was one other, higher level of scrutiny. So you have all these conditions made up by the court. See, I thought we went by the Constitution, but we go by conditions and other things that are created by the court rather than the Constitution. But one thing about the 14th Amendment that everybody overlooks. So Roberts is claiming the power to make the decision on this. That's the court's decision. No matter what it is, it's the court's decision, and we're supposed to go along with that. Section 5 of the 14th Amendment says, the Congress shall have the power to enforce by appropriate legislation the provisions of this article, meaning the 14th. So is there a law passed by Congress currently regulating surgical procedures, hormone blockers, puberty blockers for minors. Has Congress passed a law on that? I don't think they have. I think we would know if they had. Yet the court's going to rule on something that the Congress doesn't have a statute on. Now, I know this is not the first time this has happened. I know it's not. The court has taken, and we've allowed them to take, way too much power for way too long. And now we're in the mess we're in, and it has a lot to do with that. But remember, Robert said no matter what, we're the final word. You know, back during the American Revolution, or actually prior to the Revolution starting, you had the Stamp Act. The Stamp Act was the first thing that really, really got a reaction from the colonists. And they did everything they could to nullify that Stamp Act. And eventually, they were successful in nullifying that Stamp Act. You know, all of our pre-revolution stuff was nullification. That's what it was. All of our pre-revolutionary stuff. Minus the shooting Adam part, I guess. So, basically, after that was repealed, the British, now not to say that they actually stopped it, but one of the things they did right after they repealed that Stamp Act was the Declaratory Act. They issued the Declaratory Act to the colonists, basically saying, we have the right to legislate for you on any and every topic, any and every issue. You're just a serf. You're just a peon. You have no say. And when I read that statement by Roberts, that's what I thought of. That was a judicial declaratory act issued by the Supreme Court telling Tennessee and every other state, we can rule for you on everything and anything. Your kids, whatever. Think about what we've allowed to happen by this deference to the Supreme Court. First thing was, oh, you can't pray in school, even though the limitation on any kind of creation of a national religion was on Congress. Okay, you know, escapes me right now, but First Amendment issue. It said Congress shall not establish any religion. Didn't say a school board couldn't. Didn't say a school could not have a prayer. Abortion. Created that out of whole cloth. No constitutional references. Penumras and emanations from the Constitution. They couldn't even cite a power. Just emanations and penumras. That's what they came up with for the abortion argument. Later on, oh, you can't have 10 commandments in school. And then, of course, oh, you have to have gay marriage. 2 years after saying, oh, that's a state issue. So here's Supreme Court Justice, the Chief Justice saying, we have the right to declare, to rule over you on anything. Throw the rest of this out. Just throw it all out. If you believe that. And I understand that we have, to a great degree, deferred to the Supreme Court for a good chunk of our history. And it's been a mistake. It's not a constitutional mandate. During the Constitutional Convention, the Virginia plan, the reason it was rejected was, or one of the reasons it was rejected was, it was going to allow Congress to have a veto over state laws. Now, even under that original Virginia plan, the people were still going to elect their congressmen, or at least their representatives. That killed the Virginia plan. The idea that Congress was going to dictate to the states. So why would anybody believe that if they weren't willing to allow Congress to override state laws, that everybody would be fine with unelected jurists to override state laws on things that there is no constitutional power for. There's nothing in Article 1, Section 8 that even hints at a power to do those kind of things. And like I said, equal protection and due process, that's part of the 14th Amendment. Those were amendments primarily applied to the freed slaves. But even taking Section 1 is applying to everybody. Where is the congressional law that deals with minors and sex change operations? Where's that? Do we have a federal law? I don't think we do. So why is the Supreme Court even? And quite honestly, and like I say, I appreciate what Mr. Rice said as far as standing up. But a couple questions for us to think about, not just Mr. Rice, and not even the AG, who the AG, quite honestly, the AG has made it clear he agrees with Roberts. That's what he said in his opinion of the nullification bill. All federal laws trump all state laws, and the Supreme Court's the final arbiter. What do you think about that? Are you okay with the Supreme Court being the final arbiter of every constitutional question involving you, children, family, whatever? Because there's no limit. Haven't seen a limit so far. Now, even though, like I said, we have generally followed this, it's not as if the courts have stayed static over the years in terms of what they view as a legitimate scope of their power. Even after the Civil War, most state legislators and even most congressmen still believed in federalism. They may have opposed the Confederacy leaving, but that doesn't mean that they were all on board with the federal government dictating everything down to the states. But that's what we've allowed. So a couple questions here. Mr. Rice made the correct point that the court lacks the authority. So if the court lacks the authority, why defer? And I know this is going to seem radical and crazy, but my thought is, you don't take something to the Supreme Court that you think it would be illegitimate for them to overrule you on. If you think it's a total violation of our Constitution, if you think they don't have the legitimate authority, why even take the case to them? Because when you take the case to them, you're implying that you're going to go along with their decision. If we defer on this, is there anything we won't defer on? Don't judges take oaths to the Constitution? Or do they take oaths to heightened scrutiny or normal scrutiny or intermediate scrutiny? Question for the people out there. If the Supreme Court rules SB 1 unconstitutional, do you want our state to defer to it? Or do you want our state to tell the Supreme Court to pound sand? I want them to tell the Supreme Court to pound sand. If they won't tell them to pound sand for this, what will they tell them to pound sand for? And if they can rule on this, and good Lord, look at all the things they've already ruled on that are not in their lane. What's next? What's next? And quite honestly, this situation, if the court were to rule, now that we've taken there, this is a perfect example of why nullification is needed. This kind of overreach, this kind of federal overreach, and that mentality. Now, I don't know how the court is going to rule. By all accounts, like I said, Mr. Rice did a good job overall, at least on those points. And based on some of the questions that the justices had for the other side, there are people that are optimistic, that they think the court is going to rule in our favor. I hope they do rule in our favor. But I hope if they rule against us, we ignore them. That would be more important. Hey, and I've said this before, we just had the election, and even though fortunately Donald Trump won, and he even won the popular vote by a couple of million, that still leaves a lot of flat out insane people in our country. They're not going away. They're not all going to join Ellen the DeGenerate in England. Most of them are going to stay here. They're going to work against the administration, and they're going to continue to work against us. At the state level, and matter of fact, at the state level, they're all better organized than most states. The conservatives in most states are not well organized. And so they're going to continue to work against us. Well, if they get the power again, do you think they're not just going to push the envelope further and further and further? No, that's absolutely what they're going to do. They're not going to stop pushing. We are not a united country. We're less united now than we've ever been. I don't see that changing. Now, I'm optimistic that Trump can do some good things, but he can't fix this country. The biggest problem with our country is we don't follow the instructions. Most of the stuff that we fund is unconstitutional. Normal people couldn't justify it. Supreme Court will buy off on it, tell you, oh yeah, we can do it because of this, or this. Which is usually garbage. It's usually they're taking something like the General Welfare Clause or Necessary and Proper Clause or something like that, which, by the way, are not additional rights. They're related, or additional powers. They're related to the powers in Article 1, Section 8. Necessary and proper to enact laws in support of something that's in Article 1, Section 8. Something that's constitutional, not something that's made up and would be nice to have. The only way we stay together long term as a country, first off, I think it'd probably take divine intervention and a miracle. But with being so different, I mean, Tennessee is a lot different. At least the people in Tennessee are a lot different than people in California, or at least the people in California that are still there, or some of the good people have left. But we're different there. We're different than the ones in New York. We're different than the ones in Chicago. We're different. All the states don't line up. It's only getting worse and worse. Hey, at least during the Civil War, everybody knew what a woman was. Everybody agreed on that, right? We are too different to stay together long term without a lot of turmoil if we're going to continue to try to push everything from the top down. We have to have a strict adherence to the 10th Amendment. We can't have this one size fits all. We can't have the federal government, the courts, pushing down their edicts. Those guys are unelected. Impeachment of federal judges is a joke. Quite honestly, the best thing our Congress could do is something it's completely authorized to do and something we should push for. Article 3, Section 2 says, when it comes, you know what, here, I'm just going to read it to you, just so I don't say something wrong. This is Article 3, Section 2 of the Constitution. Article 1 lists the powers of the legislature. Yes, everybody should have a constitution, and that's why I have this one. These are good pocket constitutions. You can get these, matter of fact, from the 917 Society. All right, so Article 3, this is judicial section, judicial power, Section 2. And I want to slide down here a little bit. In all cases affecting ambassadors, other public ministers and consuls, and those in which the state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Congress has full authority to limit the appellate jurisdiction of the Supreme Court, and they should limit the hell out of it. There's very little they should be allowed to even look at. Leave the things to the states where they belong. All right. So think about that. if the court undercuts SB1, if they say SB1 is unconstitutional, it could happen because just because you think they have a positive reaction now, you don't know what they're going to come up with. I mean, they've surprised us, disappointed us, and disgusted us in the past. Look, guys, we got two consistently good justices on there, Thomas and Alito. Kavanaugh and Barrett have been nothing but all but a disappointment. I mean, have they got a few right? Have they got a few important ones right? Yes. But overall, Barrett, Kavanaugh, and Gorsuch have been a disappointment. Now, yes, some key important ones, they voted the right way. But I don't see how anybody can know anything about the history of the country or read this and come away with thinking that this was what the founders intended, that they risked their lives, their fortunes, and sacred honor so from here on out, the Supreme Court could tell them what the deal was and tell their kids and grandkids and everybody after them what the deal is, that they had declaratory power, like Roberts wanted to make the point of the other day. So, anyway, think about that. By the way, we do have a nullification bill that's going to be back in the legislature this session. Now, there probably won't be an opinion rendered on this. Usually they do them in October and they give the actual opinions in June. It could come quicker, but it's usually the following June. Well, our session starts in January, doesn't until April. This is a perfect case. The Supreme Court rules against us. This is a perfect example. Not that we haven't had other perfect examples, like the whole marriage debacle. But nullification will be in the legislature again. It's a process bill, 5 different processes. If you have questions about that, you don't know anything about it, go to tncss.weebly.com. You can find out all about it. You can actually download petitions because we do want to take a bunch of these petitions signed by citizens. You don't have to be a registered voter, prefer you are, but you don't have to be. You just have to be a Tennessee citizen. You know, list the county that you live in, and we want to take paper copies. We want to give these to Senator Bowling and Representative Halsey prior to the session so we can show that there's support for this. But it will be back. It'll start back in committee. We need to get it passed for not only this, but other things coming down the pike. You know, one of the things the Trump administration is doing, to their credit, or they're talking about, is reducing the size of federal government. Well, that's a great idea. It's a way overdue idea. We've talked about it for years. I hope that we can actually do some of it now. Well, our state can help with that. You know what? We'll say, hey, you know what? This power that you've been exercising, we're just going to take it back. It's ours anyway. It was never yours. So, anyway, we appreciate your support. Check out our audio podcast on iHeart, Radio, Spotify, and other platforms as well. Sign up for our weekly newsletter at our website, tinformer.com. Now to the announcements of upcoming events. Please find and follow us on Facebook as well as Twitter. The 23rd Annual Bill of Rights Banquet will be held Tuesday, December 17th at Trinity Chapel, 240 First Avenue, Dayton, Tennessee. Registration at 5:30. Paid reservations, $40 each. Children under 12 are $20, and they should all be paid by December 15th. You can contact June Griffith at 423-775-0774. And you can talk to her and guarantee that you'll pay at the door, so she'll reserve you, or you can send a check to her. The theme this year is our spiritual heritage, and checks for June are, and I'm sorry I have that out of order, mailed to June Griffith, 265 Crestview Lane, Dayton, Tennessee, 37321. And remember, this is not a fundraiser. Your cost merely covers the expenses. Our guest on the show next week will be constitutional expert and attorney Jeff Cobble to talk about the most distorted and perverted amendment in our Constitution, the 14th. That's it for now. Good night from Paris, Tennessee, that is.